the State of Kansas, appeal number 109335S. With that, I'll ask counsel to state their appearances.
Alan Root for the appellees, cross appellants, John Robb and Mark Knag.
Arthur Chalmers for the state, Stephen McAllister. We also have Attorney General Schmidt and Jay Willoughby.
Very good. Based on my notes, I show that the arguments will proceed as follows. Mr. McAllister will go for 30 minutes, followed by Mr. Chalmers for 20 minutes, followed by Mr. Root for 45 minutes. After that is concluded, the court will most likely take a morning break. That'll give counsel a chance during our break to get ready for their rebuttal arguments. We'll start with the state rebuttal for 10 minutes, and then Mr. Root's rebuttal for 15 minutes. Any other preliminary matters to come before the court? With that, counsel, you may proceed.
Mr. Chief Justice, and may it please the court, I'm Steve McAllister, and it is my privilege this morning to represent the state in this matter. Although I represent the state as an entity, make no mistake that both collectively and individually, Kansas elected officials care about the education of Kansas kids and the success of Kansas schools. This case is about constitutional issues. It's not a survey to try and determine who cares about education in our schools. We all do. This morning, I will address 3 constitutional flaws in the plaintiff's case, while my co-counsel, Mr. Chalmers, will address a 4th issue. In particular, I will address the lack of standing to bring these claims, the utter illegality of the remedies the panel purported to order, and the non-justiciable nature of the claims the plaintiffs have brought under Article 6. Fundamentally, what the plaintiff districts seek from this court is a ruling that the Kansas Constitution binds us to an unsustainable model of school funding that ultimately will undermine our very system of government. The U.S. Supreme Court, however, has observed about the U.S. Constitution that although it protects against invasions of individual rights, it is not a suicide pact. The same is surely true of the Kansas Constitution, which is neither a suicide pact nor a bankruptcy pact. This morning, I begin by addressing the standing and remedies issues in this case for several reasons. For one thing, this court has not addressed these 2 issues in previous school funding lawsuits. Secondly, these are legal questions, first and foremost, the answers to which are clear and which require either dismissal of the suit or at a minimum reversal of the panel's decision.
If standing is a legal issue, why are you claiming that the problem here is there was no evidence presented?
Well, it's a legal standard, Your Honor, that the plaintiffs have to show the traditional 3.
I understand that standing is a jurisdictional legal question, but your complaint is that the facts were not put before the
Our complaint is twofold, Your Honor. There are 2 sets of plaintiffs, remember, the school districts and the individual students and parents. The lawyers for the plaintiffs here made the tactical choice to rely only on the school districts. They presented absolutely no evidence of the students' circumstances or anything else that would justify a finding of injury in fact and the other requirements for standing. So in our view, due to the utter lack of evidence to even support a claim of student standing, they're out of the picture. Then the other piece of the problem is the school districts. What are they claiming? Well, they're claiming a right to education under Article 6. But if anyone has that right, it's students. It's not the school districts. Article 6 doesn't say school districts have a right to education. They're simply an instrumentality that tries to deliver education.
Doesn't the Constitution give the local school boards an independent constitutional duty?
It gives duties under Section 5 of Article 6 to operate locally, to exercise control over schools at a local level, and the court has had a couple of cases under Section 5. We're not contesting that they may have standing to bring Section 5 claims. But if you remember, their cross-appeal goes on at great length about the fundamental right to education that they think individual students have, but even they don't claim it's their right. It's the student's right. So they're in the position here of at most asserting third-party standing on behalf of their students.
Even if they haven't made a Section 5 argument, if their duties are impeded by the actions of the state legislature and it falls under the suitable provision for finance language, can they not assert a claim?
My answer would be no, Your Honor, and I would disagree that their duties are impeded. What I read Section 5 is about is that you get some local control by a local school board over how your school operates, but that's a separate provision and a separate requirement from any obligation the state may have in terms of providing funding. They're not saying the state is telling them in inappropriate ways how to run their schools at a local level. They simply want money. I don't see how we can characterize their claim as anything other than a Section 6 claim. And if Section 5 gives them standing, then they have standing for any claim they want to bring that has anything to do with schools or education. That would be the end result, I think, of that logic, just because they're recognized as an entity under Section 5. Instead, federal law is crystal clear that political subdivisions don't have standing to bring individual rights claims. And that's what they're asserting here. They've never said in this case we're asserting a violation of Section 5. They're asserting a violation of Section 6.
And what does federal law have to do with?
Well, federal law has two things, Your Honor. One, this court has typically followed federal standing guidelines. And second,
number one, it's persuasive authority for us?
well, persuasive at least, given that the court has looked to the traditional federal standing analysis, has never suggested that Kansas somehow has a unique or different standing doctrine. And the second reason is because this court does not have a case of which I'm aware that addresses a school district's potential standing in an Article 6, Section 6 challenge. Federal law is the best, or if you want to look at other states, we can talk about that. There are states like Oklahoma that has said no standing under Oklahoma law for a similar kind of claim. But this court has never addressed the standing issue directly under an Article 6 claim. It has twice had a Section 5 cases. Only once did it even mention standing. I wouldn't really call it evaluating it. Just pretty easily concluded because it was a matter of hiring or firing a teacher. The school districts had standing to bring a Section 5 claim.
I understand your argument on political subdivisions as it relates to the 14th Amendment. Are you saying that the political subdivision notion should also apply to school districts under Article 6?
Yes, because...
So that would mean that no school district can bring any Article 6 claim?
Yes.
Even for a violation of Section 5 of Article 6?
Well, I'm sorry. I was thinking Section 6. Yes, so the school district couldn't bring a Section 6 claim. I'm not saying they couldn't bring a Section 5 claim. The point being that the section, I'm getting mixed up with all the sixes here, but the point being that the Section 6 claims, by the district's own characterization, is an individual rights claim. They are saying the students have a right to education, and I see that as no different than what federal law says about 14th Amendment equal protection and due process claims, which are individual rights. And the cases are absolutely clear. There's no standing in that setting. What they're asking for is basically wide-ranging third-party standing. Third-party standing is generally prohibited under standing doctrine unless there's some close connection, some reason the absent plaintiffs can't be part of the case to assert their own rights and interests. Here, there's no reason. They named individual students, but then they didn't show up for trial. They presented no evidence whatsoever, and even the panel said, we don't have any evidence by which we could evaluate an equal protection claim because we don't have any idea what class even these students might be part of for equal protection purposes. So they just presented no evidence. That's a tactical decision they should be held to. The only thing, go ahead.
Sorry, what about as to the equalization claims, especially on capital outlay, where a claim is being made that should have been paid to the school district?
Should have been. Well, that's all of this is they're the ones who ultimately receive the money, not the students. But what they're asserting is the effect on the student's right to an education. And the equalization, whether you characterize it as a Section 6 claim or as an equal protection claim under federal or state law, you're still talking about an individual right. And they are asserting the rights of the students, not a right that they have independently.
Do they have a due process right? Does the school district have a due process right to the enforcement of the statutes?
I don't believe so. Again, if you're talking about some sort of individualized due process notion, political subdivisions, the clear federal rule is they cannot assert such rights against the sovereign, the state that basically created them. Their main argument, I think, in response to our standing argument, is that they somehow have associational standing. But that, to be honest, just does not make sense. The associational standing cases, with which this court is well aware, having decided one very recently, a group like the Sierra Club brings a lawsuit over an environmental matter, they have to show for standing, not just that we're interested in environmental issues, of course they are, they have to show that they actually have members who somehow will be harmed by whatever it is they're challenging. So the typical environmental case, I hike, I camp, I use this property, now the government's proposing to do something to it, me and my association can bring a lawsuit. School districts are not associations of students, they're governmental entities. And under their reasoning, any governmental entity would then have associational standing to assert the rights of any single citizen that's part of that governmental unit. That's not the law and shouldn't be the law. The second issue I'd like to address.
Before you move off of that point, are you familiar with State XREL Board of Healing Arts versus Burrell, in which this court said that it was appropriate for a state agency, a governmental unit, to be able to have standing to press the constitutionality of state statute, and whether that provides an avenue for the school districts to press their claim here?
I'm not familiar with that case, Your Honor, and I don't think as a general matter that would be the rule. Now, maybe there are instances, and certainly you find this in federal law, there are examples of political subdivisions having standing to a certain kinds of structural claims against the sovereign. And I don't know if that's what was at issue in the Board of Healing Arts case, but the cases are quite clear. If you're talking about an individual right, an equal protection claim, a due process claim, those kinds of things, the answer is no. And the Tenth Circuit cases we cite in our brief talk about that distinction at some length. With the court's permission, I'd like to turn for a few minutes to the remedies issue. This is perhaps the clearest error of all in what the panel did below. Just as with the standing claim, where the plaintiff's lawyers made a deliberate litigation choice to rely solely on the districts, here they made a deliberate litigation choice to sue only the state of Kansas. That is the only named defendant. That is unlike any previous school funding litigation in this state, and that choice has significant consequences. The first, most obvious one, is when a plaintiff sues the state, certainly for any violation of federal law, states generally have constitutional immunity. So to the extent they purport even to make a 14th Amendment equal protection claim, it's barred by the constitutional immunity of the state. They didn't sue anyone but the state. So such a claim cannot be brought. There's no waiver here by the state, no consent to such a claim. Second point, courts do sometimes certainly enjoin executive officials from enforcing the law, but here they didn't name a single executive official. They didn't name a governor, a treasurer, state board of ed, anyone. They named the state of Kansas, period. So no individual officers are even part of this suit. Third, even that principle, enjoining an individual official, is limited constitutionally to executive or enforcement actions. So it wouldn't be any answer to say name individual legislators and then purport to order what the panel did, which is you must vote for a certain law. You cannot vote for laws that don't do what we say you have to do. If it's legislative activity, there's immunity, and this court's cases recognize that, as well as tons of U.S. Supreme Court decisions on that proposition. I'm not aware of any decision from the Supreme Court of the United States, using by analogy as persuasive authority, in which the court has ever purported to order Congress to pass a law or not to pass a particular law. But that at bottom is what the panel did here. said you must pass appropriations laws that authorize 4492 BSAPP. That's basically an exercise or an order to legislate in a particular fashion with the threat in the panel's order that if you don't legislate in that fashion, we'll do something else to you. What that will be, I don't know. But the U.S. Supreme Court has struck down many acts of Congress. They do it every term. But never do they say, Congress, now the remedy is pass a new law to take the place of this one, or change or repeal the old law so that it's constitutional in our view. The court declares the unconstitutionality, does not have the power under our system to force the legislature to pass a new law or to repeal the old one. In fact, if the courts had that power, there really wouldn't be a separation of powers anymore, because then the courts could control all three branches of government when they chose to, which would be ironic given that the courts in our country typically are the branch that is not elected and not answerable to the people. So I'm certainly not saying a court cannot declare a law unconstitutional. It can. But a court has to be very careful, as this court is aware, of the remedy that flows from that declaration. And telling a legislature you must pass a certain law or you cannot pass a certain law has never been the remedy that a court has applied in this setting.
Speaking of remedies, Mr. McAllister, when I was reading the briefs and preparing for today, much of the language that was used in what you presented in your briefs that you submitted today reminded me of some of the things that occurred in the last case. And I pulled the brief that you submitted in the last case in which you talk about a remedy. In fact, you're essentially encouraging us to adopt the legislative remedy that was established in Senate Bill 549. And in that brief, what you say here is, and I'll quote you, and you eloquently argued before us, I clearly adopted your point of view in my concurring opinion, but what you said then was Senate Bill 549, approved by both houses of the legislature and signed by the governor, adds $194.5 million in new annual base money to last year's $290 million and promises another $300 million or so in the next 2 years. And my question to you is, clearly the promise that you and others were espousing 6 years ago has never been kept. Essentially, it stands before me in my eyes as a broken promise. And it wasn't a promise that was conditioned on financial conditions. It wasn't a promise that was based upon any kind of change in the formula or in local state option budgets. And what I'm curious of, and what your take in that is what are the realities? You're talking about a remedy. We can't, and I agree, we can't order the legislature to pass certain legislation. But when you come in here and promise something and then never fulfill that obligation, what are the realities that we're dealing with, and what are the ground rules we're confronting here? Because if that promise had been kept, we wouldn't be here. And that promise has never been complied with since that time.
Well, Your Honor, I think we're going beyond the remedies into my other issue, and I'm happy to talk about that as well.
I agree. It crosses into justiciability, but it also crosses into the remedy you propose. I mean, I bring it up now because I was going to wait to justiciability, but I think what you're talking about is this was your remedy. This wasn't Ogden Blinken-Myers. It wasn't legislative post-audits. It was the executive branch and the legislative branch, the remedy, coming to us saying, this is it. This is what we'll do. And then you didn't do it.
Well, I guess I don't take ownership of that personally.
No. Please. I know you're an advocate, and that I understand that's not your ownership. But what are the realities we're dealing with here? You say we can't
right.
order something, but what parameters do we have? We certainly don't have the legislature's word because it's subject to change. We're dealing with an administration that was a different governor then. A different governor confronted the issue in 2008, 2009. Now we have a different administration. What are the realities here?
Well, the realities are, again, I think that goes very much into the justiciability territory, but it is relevant to the remedies, and I'd like to talk about that as well. The realities are legislatures are responsive to the people who elect them. They're responsive to the realities they face. They have kids in Kansas schools. They know Kansas schools. They also realize that the Great Recession came and the revenues went in the tank. Yes, at times government has aspirations that it then struggles to fulfill. But I would remind the court, among other things, as you suggested, the decreases in funding that occurred here started with a Democratic governor, have crossed administration. It was not what I would certainly not characterize as a purely political partisan maneuver. It was an economic reality to some extent. And those statutory projections, they're always promises in the sense, but not breach of contract kind of promises. That's one of the flaws, I think. The panel treated it as though there was an inexorable command. Once the legislature said at any point in time, this is what we'll do in the future. If you don't live up to that, we're going to hold you to that as a court. But that's not how legislatures work. I mean, all appropriations are subject, or many, to allotments, to changes in conditions.
But Counselor, this is different. The dismissal of Montoy was induced by that promise. Obviously, promises are not binding when you're talking about appropriation of funds, but the dismissal of that case was induced by that promise, and that promise wasn't kept.
Well, Your Honor, if the suggestion here is that there was a bad faith promise to conclude the Montoy litigation, I disagree with that. I don't think so. I think the legislature was doing its best. It came up with substantial funding. In our view, there may be parts of Montoy, to be honest, where the court was overreaching a bit in terms of the remedies it was requesting. The legislature responded, the governor responded. Things change. The people change. The conditions change. Again, if we're going to say, that's what I meant when I started out with what's probably an unsustainable model of school funding. If we take the panel's view that it all depends on these studies, and the legislature is wedded to what the study says, then what it means, rightly or wrongly, at the end of the day, school funding has to increase, first of all, a huge amount to catch up to whatever the studies think we should have been at, but it will never do anything but increase over time. It's already 62% of the state's general fund budget. Under the plaintiff's view and the panel's view, it's going to be a lot more than that. And it's an inexorable increase. Nobody thinks costs go down generally over time, so the assumption will be it's always got to be more year after year. And in my view, that's not the court's job or authority to enforce that kind of a bargain, if you call it that, on the legislature.
Can we pivot back to the remedies?
Sure.
And you were arguing that the judiciary can't order the legislature to pass a new law. Is this a new law, or is it a failure to appropriate and fund the old law?
Well, I think the statute has a target, but if decisions are made and they pass a budget that doesn't fulfill the target, then as far as I know, the only way to fix that is they're going to have to pass a new budget, which is a law.
So when they appropriate less than is in the legislation, that's the law?
Well, certainly, I'd call anything that takes a vote of the legislature and the signature of a governor to
And
be a
the
law.
reason I take that or ask that is because of your argument that this case, it can be distinguished from Montoy because Montoy was looking at the flaws in the law, in the statute, in the scheme, and here you're only talking about money. But if you're saying the appropriated amount is the law, then why isn't the same? Because we're looking at the law, which is the appropriated amount, not the aspirational law that was passed, but the one that was funded. So I don't see the distinction between Montoy and here.
Well, and it may be that at the end of the day you don't see a distinction. We certainly think there are ways it can be distinguished, but we also think at some level portions of Montoy go too far. And that's a problem.
Well, that's a different question that you disagree with the holdings in Montoy. My question had to do with your argument that it's not germane to this case because this is a different case. And I'm having trouble seeing why it's a different case because we have a complaint about the law passed by the legislature, whether it's through appropriation or whether it's through a bill, and that it doesn't comply with Article 6 of the Constitution.
Well, and I guess it depends a little, Your Honor, what you mean by a different case. Certainly, it is actually a different case. Montoy was terminated. It's over. So this is a new case with new plaintiffs, some claims that relate back to Montoy, perhaps new claims, new court. It's a new case in that sense. And if the court views it as just a continuation of Montoy, then Montoy should have been kept open, but Montoy was terminated. So I think we have to step back.
Counselor, I think you know what I'm talking about. We're talking about issues, or the same issues, and is Montoy authority that we rely on. It makes a big difference if Montoy is binding precedent or if we're dealing with issues that Montoy didn't address. Whether we have to overrule holdings of the prior court.
Well, I think 2 points, Your Honor, as we've argued. One, we would accept limiting or overruling Montoy to keep the court out of this business in the future. But Montoy, at bottom, the whole formula got rewritten because there was all sorts of questions and problems about the weighting and whether certain kinds of students were being taken into account in a proper fashion. All of that was in play in Montoy. There's no claim here. In fact, basically, there's no question that the underlying formula system is constitutional. At least they haven't challenged that. The only issue is whether the legislature has put enough money into that formula. But there's no question that school districts are receiving what the formula says they receive, given the amount the legislature has put in to the fund. So in that sense, it is different than Montoy. Montoy, the court had significant problems with the entire system. Here, it's not that the weightings are off. It's just that the districts think there should be more money in the pot. And I think in an ideal world, people would agree with that. But the legislature has to deal with the real world. And the real world is the state had a significant change in economic conditions beginning in 2008 and going forward. And that's what I started off talking about. The Constitution shouldn't be a suicide pact. It shouldn't commit us to an unsustainable model that ignores, because under the panel's view and under the district's view, the panel says this, economic realities don't matter. They're irrelevant to the question here. And that's frightening if that's true, because that means the legislature confronted with dire economic circumstances. Well, one thing you can't do is touch the school's budget. It has to keep going up every year, no matter what else is going on in the state, no matter what that means for other parts of government or other functions the state provides to its citizens.
I thought the legislature passed a law that said educational funding's got the first priority. So why don't we just hold the legislature to what they said?
Well, again, Your Honor, I guess the notion...
Isn't that true? They passed a law that said educational funding will have the first priority.
Well, and they can change their minds about that, and I don't know that they have to
and
rewrite
not repeal the law. That seems at
statute.
least hypocritical.
Well, but, Your Honor, with Article 6, if you remember the amendments in 1966, one of the arguments that featured prominently over the amendment, in part what we're talking about here, there was a proposal to make the legislature do 2-year budgeting for schools. And in fact, that proposal didn't fly and didn't make it into Article 6 because the response was, well, that will put education as the top dog, always first, the highest priority in state budgets. And there was a negative reaction to that proposition. The point being, the legislature needed some flexibility in determining funding priorities from year to year, and schools didn't get this special status. We're certainly not up here arguing that education is unimportant. It's very important. We all recognize that. People care about Kansas schools and the success of our kids, but at the end of the day, is this a question that a court can really resolve?
Before we get there, I've got another remedy subject, and I don't want it to get lost. And it pertains to KSA 726405, which is the non-severability provision in the Act. And what it does, if you're not familiar with it, is it identifies a bunch of provisions that were passed in 2005 and 2006 and says this constitutes the SDF-QPA Act, and if any of those provisions are stricken, then the whole house of cards falls. All of them are going. Now, I went back and looked, and I can't find a Kansas case that has dealt with a non-severability provision. We have lots of severability, and we have some cases. And our severability case law seems to say that, well, we don't have to take the legislature at its word when it says it's severable, that if it looks important, we might strike the whole act. But on non-severability, it looks to me like the case law around the country is split between whether you hold the legislature to that language or if you do an analysis similar to what you would do with severability. What do you think we do if we want to nick one of these provisions but not the whole thing? Do we have to take the legislature at its word and knock the whole house of cards down?
Well, perhaps would be my answer, Your Honor. My understanding of severability doctrine, you're right, it's not typical that you have non-severability clauses. You either usually have a severability clause or nothing in the law. But this court and others have said the key really is the intent of the legislature and whether this legislation could function without the piece that we're striking out. It seems to me then the call is, do you separate legislative intent from whether it can function without? It may be it can function without a particular provision that is stricken, but you're certainly going against the clearly expressed intent of the legislature given that provision. Which one prevails, I guess the court would have to decide, but those two might be moving in different
You're not
directions.
going to help us by telling us which one?
Well, maybe you help me by telling me which pieces you want to strike down, and then we can decide whether they should be severable or not.
Well, but no, because if that's the case, then the court's doing an analysis of the significance of the provision vis-a-vis the whole act, as opposed to just doing exactly what the legislature said.
And that's where I see the tension, because it seems to me if the legislature has gone to the trouble of saying we don't want anything to be severable, certainly if the question is asked, what would the legislature want if we struck down a provision? They seem to say in that provision we'd want the whole house of cards to fall. That's maybe a different answer than if a court or someone independently looked at it and said, will this law work without this offending provision? It may work, but that seems to me then you're going against the legislature's clearly expressed intent. So at least tentatively, that would be my answer, again, without knowing for sure where we might go with this, that if they express that intent, that's what they wanted, and that should be the primary concern in a severability analysis.
But their actions speak differently, don't they? Because the legislature itself severed some of the provisions or failed to fund some of the provisions which effectively eliminated them from the scheme, didn't it?
Well, I don't know that they have eliminated anything, Your Honor. They may not have hit certain targets that were projected. There is still supplemental state aid. Now, at a certain point, the capital outlay equalization stopped, but it's on the books, and economic conditions can change. It can be used again. I wouldn't read any of that as the legislature itself has nullified or taken out of the statute particular provisions.
But I understood you to say earlier that what they actually funded and appropriated, that was a new law.
Well, sure, in the sense of they had to pass a budget and the governor has to sign it. I'm really at a loss if that doesn't count as a law.
But for severability purposes, it's still the law, but not for funding purposes. Is that what you're telling me?
Well, I'm not sure, Your Honor. What I'm telling you is ordering a legislature to come up with a certain amount of money and pass a law to do so or not pass a law that fails to do so is beyond the court's authority. Whatever you want to call the circumstances there. And so with all of this, at bottom, I think what we're getting at, among other things, is just how complicated this is. All sorts of assumptions, subjective judgments, decisions that have to be made about what it takes here to run a Kansas school system. My co-counsel, Mr. Chalmers, can talk about a lot more of the details of the success of the Kansas schools and so forth. But at the end of the day, the panel didn't find that there was an inadequate education being provided to anyone, or not an opportunity for an education under the Kansas Constitution. And that should be the end of the inquiry. I'd point the court again, as we have in the briefs, to our surrounding sister states that have dealt with this recently post-Montoy. Oklahoma said, no standing, we don't go there, not a justiciable question. Nebraska said, we won't get into this. We don't want to be drawn into a litigation. They point at Montoy as an example of what they don't want to do. Missouri said, well, there may be standing for a particular claim or claims. They have a constitutional amendment that says a minimum of 25% of the general revenue has to go to schools. We can enforce that. But beyond that, it's basically a rational basis review. Iowa said, don't ask us to rewrite the school standards as an Iowa Supreme Court. It's not our job. That's not our place. And Colorado had made a decision, like this court did in Montoy, years ago, that there was a justiciable question. But when Colorado encountered budget cuts in recent years, and that was challenged, earlier this year, the Colorado Supreme Court said, we know there's a question here, but our review needs to be deferential. It's rational basis review. And it is certainly rational to take into account current economic conditions when deciding how much money we provide to the schools. So,
Can I question you on your standing argument? I think I understand. Is your justiciability argument an alternative, basically if we get past standing, or do you think we should consider justiciability even if we decide that there is no standing?
well,
Because I guess my concern is, if we say there's no standing, arguably they could go back and amend their petition and assert standing properly, perhaps, the right individuals. But then we would still be faced with a justiciability question eventually. So I'm just wondering what your position is on that, and if you distinguish between the two.
well, you're absolutely right. The standing, I actually would require dismissal of the case. And then if they wanted to start over with a new group of plaintiffs, they could try that, but it would be a different group of plaintiffs if the court were to accept our arguments, for example, that the districts don't have standing to assert the rights of the students. They could not be part of the picture. It would have to be individual students in a new lawsuit. That requires dismissal. Non-justiciability, you wouldn't have to decide standing if it's non-justiciable, because nobody can bring the claim and have a court answer the question. The third issue we present, the deferential review, we think we prevail on that, but that is a merits determination. So, even there, I suppose if the court did that, it wouldn't have to resolve the standing, or at least could say even if there's not standing. Well, actually, I don't think you can do that because it's a jurisdictional issue. So I think the court's going to have to find there is standing. So non-justiciability and standing would be jurisdictional bars potentially. Our third issue is merits, deferential review. And then the fourth issue, the remedies, I'm not arguing that's dismissal of the suit. That's just about if and when a court finally does get to proper plaintiffs, an issue we can decide, and there's a violation of Article 6, then what can a court do about it? So that one is reversal of the panel, but certainly not dismissal of the suit. But yes, I guess to try to, in a nutshell, standing, the court, I think, needs to address before it can go any further in the case. Justiciability, it's a question of how the court reads Montoy, whether the court rethinks Montoy or not. Then merits, then remedy. I chose to talk about remedy and standing first only because they're the two issues that I don't think there's really much law on in the previous school finance cases. They certainly didn't address standing, and there really wasn't discussion of remedies in the way I'm talking about it in the Montoy litigation either.
So I've got some problems with your justiciability argument when I compare it to like Article 11, Section 1, the uniform and equal taxation provision. I mean, there's a boatload of case law from this court deciding when the legislature has violated that constitutional provision. And when you go back and look at some of that case law, even going back to the 30s, you have this court saying things like an element it will consider is whether the exemption furthers public welfare, which seems to me to have the court really in the weeds when it comes to public policy. What's the difference between Article 11, Section 1 and Article 6?
I'm glad you asked, Your Honor. I'd like to address
I'm glad you're glad.
So the provision like a uniformity provision, as I understand those across the country, many state constitutions have those, particularly with respect to taxation, and I'm not aware of cases saying courts lack the power to decide whether a tax is uniform in its operation and effect. But that seems to me a fairly straightforward. Now, yes, you may bring in policy judgments in evaluating the legislature's actions. The difference here with Article 6, I have two problems, at least, with the justiciability of what the plaintiffs are asking the court to do. First, to the extent Section 1 says the legislature shall provide for educational, scientific, vocational, and so forth improvement, that was originally, and in our view still is, aspirational. It's not mandating.
So why did they change the language? What was the purpose of that? I would agree the prior language, pre-1966, was aspirational, or arguably aspirational. This is shall
it still was just maybe a little stronger way of phrasing the goal, but I don't think it changes the aspirational nature. There certainly weren't people that I'm aware of in 1966 talking about, now this means that every single year the school's test scores must go up or Section 1 is being violated. That seems to me an impossible duty or demand on the state. The other provision, though, is the pseudo provision for finance, and this is where I think we really get lost. This is where Montoya eventually, in my view, got off the track, and it's certainly what the plaintiffs pick up on. It doesn't say suitable education. It doesn't say adequate education. It says suitable provision for finance of the educational interests of the states.
And it doesn't say financed by others.
No, it just says suitable, the state shall make suitable provision for finance. If I have a child in college and I'm going to make suitable, which I do, suitable provision for finance, does that mean I have to pay every dime of my child's expense? What if they get scholarships? What if there are other ways they can work for somebody, income to help pay their suitable provision for finance? Doesn't say the state must finance the schools with direct state money. It says only the state shall make suitable provision for finance. And any rational financer, at least me as a parent, would say if there are other sources that will help pay for this, that's suitable. There's nothing illegal about it, and it's only sensible that the legislature would take into account federal funding, local funding. I mean, of course, there's a transition in Kansas history. The local funding used to be, by and large, the source. I mean, this court's cases talk about it. It's not until much later that the legislature becomes so central in some ways in providing finance directly.
Well, it happens in the late 30s when they start putting state money in, and they do it because they know the property tax in some areas can't carry the load. Is it your view that the legislature could pass a law that says all schools will be funded only locally by the property tax in their district, period? Would that fulfill the obligation of Article 6?
It might, although there I think the court would have a better basis for saying, certainly looking at equal protection sorts of arguments that might be made. That might be suitable provision for finance. It might still be an equal protection problem if there's huge disparities.
Well, of course there will be. I mean, we know the difference between a mill levy in Galena and a mill levy in Burlington. And so with that reality, could the legislature pass a law that says only the local property tax is going to finance local schools?
If that's a rational decision, then probably yes.
How could it be a rational decision? Can Galena run a school system only on its local property tax?
Well, again, Your Honor, I'm saying I'm not sure that's a violation of Article 6. It may be a problem in other respects, constitutional challenges that could be brought. Article 6 doesn't say all school districts get equal funding.
I didn't say that.
No, but that's the
When one
implication,
mill
I
equals
think.
$15,000 in Galena, and another mill in Burlington equals $350,000 or $400,000.
Understood, and I understand, and that's the very system, certainly, that under the federal Constitution, the Supreme Court said was rational, because that's largely what Texas did in Rodriguez. And what I'm suggesting is, if there's a problem with that, it may be an equal protection kind of under the state constitution question, but it's not necessarily in Article 6. The problem with Article 6, Section 6, make suitable provision for finance, is so vague. What's suitable may be in the eye of the beholder, and that's why we're asking for deferential review here.
But isn't it, in our eyes, you're talking about the separation of powers, but the determination of what that phrase means in Section 6 of Article 6 is the job of the judiciary, is it not?
Well, certainly.
And it may be vague, but it's incumbent upon us to say what it means.
It is, but one thing you can say what it means is that that's primarily a decision for the legislature to make, and so long as it's a rational decision, it satisfies suitable provision for finance.
We could say that, but what we're here about is for us to look at that language and determine what the people said in 1966.
Exactly, and I don't think, with all due respect, Your Honor, and I'm going to transition to Mr. Chalmers here unless the court has more questions for me, that the people in 1966 thought they were imposing on the state a whole lot of requirements about actual costs and cost studies and BSAPP and what level it has to be exactly. I mean, they were emphasizing education is important to Kansas.
Do you think the
Agreed.
people in 1966 intended suitable provision for financing the educational interests of the state would be determined by political influence and voter diligence?
Yes, I think to a great extent that's what they had to have expected. I mean, that's how it had always been done. I think there may be certain interests in the state who viewed it as an opportunity to bring litigation to try to influence the public debate. But that's a fundamental point here. The Kansas legislature and the governors, they answer to the voters every 2 to 4 years. If people believe that education is underfunded in Kansas, there are a couple very easy answers. One, have the legislators appropriate more. 2, get a constitutional amendment on the ballot to make clear what it is the people want enforced.
And my problem with your answer is when I compare and this is what the Peabody Court did back in the early 70s, when I compare the language in Article 6 that's used for public schools, where we have the mandate, we have the shall, the legislature shall do this, shall do that when it relates to public schools. Then when we get to higher education, it says may. And if you're right, they didn't need to use different language.
Well, I think with the higher education, my recollection is the provision is they may enact a certain kind of levy to help fund higher education. Actually, you bring up another point. If the plaintiffs on the panel are right here, Your Honor, it's not apparent why higher education is excluded from the protection of Article 6, Section 6. It says suitable provision for finance of the educational interest. It doesn't say for the K-12 schools.
It doesn't, but you've got another sentence in Section 6A that relates to higher education, and it says further appropriation or other provision for finance of institutions of higher education may be made by the legislature. I'm saying there's a difference between the use of the word may and the use of the word shall. Because if you're right, they didn't need to use the word shall, and that's the plain language problem that I'm having with your argument on Article 6.
Well, and we could go around all day, probably, Your Honor, on shall and may. I mean, there are lots of provisions in statutes and constitutions that say shall, but obviously are not interpreted necessarily in all circumstances to their utmost as an inexorable command that cannot be anything but followed no matter what the end result is. And there are a number of other provisions, I think we cite some in our brief in the Kansas Constitution, that say shall, but they have not been understood in the way the plaintiffs are asking this court to understand Section 6. With that, unless the court has further questions, I will...
I have a I do have a question.
Okay.
In the deferential review, what is our standard? You have mentioned rational basis several times today, but I understood in your brief you were arguing the standard of arbitrariness. And you cited 4 cases there that to support that. I looked at those 4 cases and I was unable to determine where those courts came up with that standard. It kind of looked like they just said, that's what we want to do, so that's what we're going to do.
Well, one of those
Is there a doctrinal basis for either, and if so, what is it? And which one are you advocating for?
Either is fine. I do think rational basis is more the traditional, as a teacher of constitutional law, that's a well-recognized in the constitutional arena standard. The arbitrariness sometimes is mentioned in due process cases or administrative procedure cases. Maybe that's what, the Texas Supreme Court is one that talks about arbitrariness. I'm not sure at the end of the day there's a real difference. I mean, it seems to me both of them are suggesting considerable deference unless there's just utterly no reason to have done what the body being reviewed did. If there is a reason that makes sense, then it's both rational and it's not arbitrary. So I'm not sure there's a difference. But I agree with you. Rational basis has a much longer pedigree in constitutional doctrine than arbitrariness.
Does it make a difference if we're still talking remedy? I mean, this kind of loops back to the questions about, we dismissed Montoy because we thought there was a remedy. That remedy was then wiped out. And I really read the district court panel's decision as pretty much being an enforcement of the remedy in Montoy. And because of that, I think that they even, without saying so, shifted the burden of proof somewhat to the state.
Well, I think they did, but I don't think that's appropriate, Your Honor. For one thing, the plaintiff specifically asked the court to reopen Montoy before they brought this lawsuit, and the court declined. So I think legally and factually, one has to view Montoy as over, and this is a new suit, and the burden is on them to show the constitutional violation, at least as an initial matter. And as you suggest, Montoy says if you get to the remedy phase, then things may shift a bit. But there has to be an initial requirement on the plaintiffs here in a new lawsuit after the court expressly refused to continue the Montoy case. They better show what is the constitutional violation that justifies any action by the trial court.
Some of our sister states haven't taken that approach. Connecticut's a prime example. They've said, look, if you're not going to live up to our past case law, we're going to hold you to a higher standard of scrutiny, and they've applied a stricter scrutiny in subsequent cases. Why should we not do that?
Because I think the better reasoning comes out of our sister states in the Midwest, to be honest, Colorado, Missouri, Nebraska, Oklahoma, all saying either we're not in this at all, or if we are, it's very deferential. I think the New England and the eastern states, New Jersey is the most notorious example. Connecticut's had a lot of issues with school finance, and I'm not sure at the end of the day the resolution for the people or for the state is any better. It's just a lot of complicated, protracted, bitter, and divisive litigation. And that's what I'm hoping Kansas may bring an end to, or at least not continue in this particular setting. So I simply wouldn't find those cases to adopt the best approach to the kinds of issues being presented to this court.
Can I ask one more question? Sorry. You mentioned Article 6, Section 6, and I wonder what you make of this court's statement. I think it was in Montoy 3, the brief little opinion, where it indicated that there might be some sort of a adequacy requirement in Article 6, Section 1, but then it wasn't talked about in Montoy 4. What's your response to that?
Our response to that is it's not there. It's just not there. And so when the plaintiffs talk about a suitable education, or they say things like Kansas requires an adequate education, well, that could only come out of court opinions because it's not in Article 6. And there are plenty of state constitutions across the country that use words like adequacy, efficient, thorough, uniform. Those are common terms to describe the school setting, but our Constitution doesn't use any of those terms.
Well, the way I read it, the court seemed to be indicating that the provide for intellectual and educational improvement was the key word, and that improvement indicated something that's not static.
I agree that's the way the court read it. I disagree that that's the most logical or the best way to read it. So, because what it suggests is that there is a never-ending ratchet that schools have to have better results every single year or you're not providing for improvement. I just can't imagine that's really what the proponents of that thought they were doing. They wanted to make sure we had schools. They wanted to make sure there were community colleges, higher ed, K through 12 schools. That's opportunity for educational improvement. People can go to school and get an education, but mandating that every year everybody has to get a better, in some sense, education than the year before just seems to me unsustainable.
No, but if the people wanted to have schools, presumably they wanted the schools to teach something. And so I think those have to go hand in hand. Now, whether it goes to an extreme on the other end of improvement every year or 100%, or there could be no achievement gap, I mean, I don't think we look at that, but I think we do have to look at a minimum floor kind of level. And if the Constitution and the people are saying we want schools, presumably they want education to occur in those buildings. Don't you agree?
Absolutely, and I agree with your proposition, Your Honor, that it's a minimum floor that should be the court's focus, not an ever-increasing ceiling, which is the way, frankly, we read the panel's decision and what the plaintiffs are really seeking here.
And if we're getting into the business of looking at a minimum floor, then we're in the business of Article 6, and it's not, so we get past justiciability, and then we're looking at...
Well, I mean, you can take that view, but again, if you go there, our response would be that it's not what the plaintiffs seek, and it's not an ever-increasing obligation on the state financially or otherwise. There is a minimum floor. We've got to make sure the schools do a certain amount, absolutely. But it's unrealistic to think that the numbers just keep ratcheting up year after year after year, and that somehow ensures that the students are getting a good education.
And don't you think that minimum floor has to have context with what's going on around the country or even around the region? I mean, what I'm thinking about is, you get into Eighth Amendment kind of challenges. Well, what's cruel and unusual? Well, it's who knows what cruel and unusual, so we look around to see what's happening. Does that concept have applicability here?
Well, I think it could in assessing what's rational, and if Kansas were dead last in every category, that certainly might suggest we're not meeting a floor that we might want to achieve. That's far from the truth here. The other piece that Your Honor is well aware of is there's a very significant federal component here as well in terms of federal law that is also influencing across the nation the content of curriculum and what's going on in the schools. So there's that as well. But I don't think there's any evidence to support the notion that Kansas is at the bottom, for example, of the states. Quite the contrary. There's a lot of evidence that it does very well on a number of measures. So if we're talking about a floor, then it seems to me you have to stay away from the bottom, but you don't have to be number one in the country necessarily. That pushes us towards a ceiling instead of a floor. All right. With that, I'll turn the podium over to Mr. Chalmers.
Before you sit down, let me ask counsel if we have any further questions.
I do have one. I just want to make sure I'm clear on Section 6. So your interpretation of the provision the legislature shall provide would incorporate the legislature looking at all other sources of funding and then deciding what holes need to be filled?
Absolutely. I mean, sort of budgeting based on what it knows is available to the schools doesn't
That would
mandate
be
it comes.
federal, that would be local school districts. So, but doesn't it kind of circle back around then if the legislature's withdrawal of funding creates the holes that it's now saying it fills?
Well, except, Your Honor, in our view of the facts, there aren't the holes. So the point would be...
So you're on an outcomes approach then?
Well, looking at an overall inputs to the school system, if you take into account the federal money, the local operating budget money, the state, the BSAPP money, that total satisfies even some of the cost projections the plaintiffs want to rely on. The flaw, in our view, one flaw in the panel's decision is focusing solely on the BSAPP. And that's where the court fails to take into account that suitable provision for finance can and should include reference to other sources of funding. I mean, if there was some private corporation that said, we want to give $100 billion to Kansas schools, it would seem to me nonsensical to say, well, but the legislature's got to maintain the BSAPP, even though the schools don't need the money now. But that's really the logic of the plaintiff's position, is that money all has to come from the state, no matter what else is out there and what other funding sources the schools have.
Any further questions of counsel? Thank you, counsel.
The clerk instructed I tell you my name. It's Art Chalmers. The issues that I want to discuss presume that the case is justiciable, that there is standing. And I think they go to then whether or not the findings, both legal and factual, by the panel are supportable. It's our position that there are findings that were made of a legal nature by the panel that infected both not only its conclusions of law, but its findings of fact. And the predicate for that, I suppose, the first one would be the deference that should be accorded to the legislature in its passage of laws. And yes, there is a law involved here. It is an appropriation. KSA 72-6410B2, and there are similar provisions. That's the one that deals with the VSAP or the base. Says that when you appropriate amount each year and it ends up being a sum that is less than what would be the statutory stated base, that becomes the base. So it is an appropriation law each year that triggers what is the base, and that is what is, in our view, entitled to review on a presumptive basis. This court has said in countless opinions that there is a constitutional presumption or a presumption of constitutionality to the passage of laws. I think that the source for that statement made after Montoy, before Montoy, as recently as last Friday, is separation of powers. It is the respect between the co-equal branches of government. And I think Justice Luker had asked about the Connecticut opinion and wondered about what our position was on what the deference should be that is provided. I think the foundation for that is in the separation of powers notion, in that the legislature, when it makes legislative decisions, should be accorded deference. If we say that there is one statute that becomes constitutional for whatever basis at one time, so that now a presumption of constitutionality will not apply once we're again before the court with a different statute and a different set of facts, it seems to me that undercuts the separation of powers rationale, the one that this court has carefully used and employed over the years. There are a couple of cases that are cited in the brief that I want to call out to the court's attentions in particular, because I think they help express the point that I'm trying to make. One is the Injured Workers versus Franklin. That's the 264 Can 293 case. That case involved a challenge to workers' compensation law. And the important part of that decision, as it is mentioned here, is two parts. There was a challenge to a scheduled injury for an upper body injury to the shoulders, as to whether it should be scheduled or whether it should be whole body. And then there was a challenge as to the cap on what attorneys could charge in a workers' compensation case. And the court heard some testimony, that is, the state court heard some testimony, and concluded based on that testimony that it was not rational for the legislature to have drawn a distinction between a whole body injury when you have an injury to legs and a scheduled injuries when you have an injury to arms. This court looked at that and said, look, that decision it has no, well, it says, it is not the place of this court to determine which medical evidence the legislature should have relied upon. And it decided that that fact determination was one for the legislature based on that presumption, based on the separation of powers.
And what constitutional provision was driving that?
That would have been a due process decision, and also I think it would have included a remedy section of the Constitution similar to what was...
Was that the issue before the court?
Those were the-
Whether the legislation fit within Section 18, right to remedy?
That was one of them. There were multiple challenges, Your Honor. There was a equal protection challenge in the Kansas versus Sage Storage case. That's where what they did, actually it was a police powers case, that was where what they did is they had passed a law saying you can't use and sell milk that has any additives to it. And there was, again, a clash in testimony as to whether it was really harmful to have the additives placed in the milk. But the court said, in responding to that, if the character or effect of the article be debatable, the legislature is entitled to its own judgment, and the judgment cannot be superseded by the views of the court. In the downtown bar and grill case decided more recently, the court looked at whether or not there should be exempted, or whether there was an equal protection challenge as it related to what I'll call a grandfathering of certain private clubs to be able to continue smoking. And the court said the legislative choice is not subject to a courtroom fact finding. And then it said it may be based on rational speculation. Here, what we have is the panel making fact findings, and fact findings that cannot be accorded any weight because it applied the wrong standard of review.
I'm not sure I track this, because it seems to me that if courts simply hold the legislative branch of government to the educational standards that the legislature has independently enacted into law, that there's no intrusion by the court into any kind of public policy. We're just looking at the statute and saying, are you meeting the standards that you yourself have set?
Let's use an example to try to drill down my position, and that example would be whether or not providing more funding, or for that matter, allowing for marginal reductions of funding instead of growth of funding, whether that impacts the achievements on students. There is a debate countrywide as to whether if we just pour more money into the school system, if that's really going to produce increased academic performance. Now, this panel felt that yes, it would, or at least came close to saying that. Studies would suggest the opposite, and those studies were produced at trial. Who makes the decision on what's right? What the case law that I talked about would indicate that that choice is made by the legislature, and as opposed to being made in a fact room or a fact finding in a trial. And there's probably a practical reason for that, and it doesn't deal with the particular example that I used, but it does more globally. And that is, when you make decisions on funding of education, it is a moving target. We had a trial now, almost a year ago or more, when the facts looked at things that had happened almost a year before that. And yet here we are talking about the constitutionality of present funding. It is a quintessential legislative process here we're involving ourselves in that does not and is not well treated in a trial situation. And it does not make sense, if we look at the case law, to take what the Article 6 says is a legislative, in a legislature's determination, and turn it into a decision-making by a trial court, or in this case, a panel. In the Miller versus Johnson case, most recently, the court said it's not necessary for the court to make factual determinations on whether the cap would lower insurance premiums or has lowered them. At least the majority did. And I think what the court was saying in that instance was just this, and that is we're looking at, in these constitutional provisions, what the legislature could have reasonably or rationally done, where they make that judgment, they use their, and take their position on it, as opposed to the position of what a panel might find, or what a court might find, based on testimony that inherently is old by the time they make the decision.
And isn't that inherently just a problem in all of these cases that are brought, is that, as you said, it's a moving target, but also what's moving are the standards in which these students are measured. is constantly a moving target. At one point in time in this case, I think you were using, or the state was using, No Child Left Behind, and now there's a waiver, as I understand it, to those requirements for either the past academic year or this academic year. I'm not quite certain, but it's, and then there were now new standards with Common Core perhaps adopted to measure student achievement. And as I understand it, not in the record anywhere, there's questions of whether that standards are even going to apply in the future. It's a little bit, as I was thinking about this, it's like if you're in a basketball game and you've shot a shot, the height of the goal keeps moving while the shot's in the air. And that seems to be what we got here, is that we have a constant change in the measurement tools that are being used. And how does a court ever grasp what is occurring and try to equate that to a floor of what is required?
And I think that is the point that Mr. McAllister was making in part, in that it is almost impossible to find a measure constitutionally that you can assess or determine whether the state has met it in its level of funding. But
there has to be a floor, doesn't there? Doesn't there have to be at least a floor where there's a measurement can take place, either in terms of academic achievement or in terms of funding? There has to be some level.
For it to be justiciable, I agree.
Yes. And how do we determine that?
Well, I would say to you that the state's position is you can. But what the court said in Montoy is that what we do is we look at what you have put in your statutes to define what the required education is. And in 229, and then in Montoy, they said we look at your accreditation standards. And in fact, when you look at accreditation as it presently exists now, it's different than Montoy. We have a statute now that sets out the factors. We have administrative regulations that are in place that weren't in place in Montoy. We have, as you pointed out, as is necessary in education, a constantly evolving set of standards that are different, and we're looking at different targets, which are all now part of the accreditation process, which was found to be, or which we argue is rigorous and is applicable. And the uncontroverted testimony was that there was not a single school in Kansas that was unable to meet these accreditation standards. Now, there were some findings of facts that would offer, or that were suggested by plaintiffs to the panel that were not accepted. They were, while this court does consider accreditation standards as a base measurement, this is not an accurate and complete measure of whether students are receiving a suitable education. They didn't make that finding. They said the current standards under QPA do not reflect high academic standards, and moreover, the Kansas standards are low compared to other states. They did not make that standing. Or that finding. There's no finding in this case if the standard is what was suggested in Montoy, and which was found and applied in 229, that the academic standards here are insufficient, or that there is funding that does not meet those academic standards.
I need to circle you back to Article 6 for a second. If the legislature passed a law that said, times are tough, or we just don't like education anymore, so we're not going to pay for it, we're going to stop at grade 6. We're just going to have grade K through 6, and a half day for K at that. Has the legislature complied with Article 6?
I think that if you look at it from a justiciability standard, you don't get there because we have no way to measure it. Assume justiciability.
First of all, you would say that there's no remedy other than political sweat.
Vote them out.
Okay. But assuming
that there's justiciability and assuming that 229 and Montoy apply, then I think we're looking at whether or not you have accredited schools and whether you have funded to the level that that you can meet the requirements of those accreditations. I think that answers your question.
No, it doesn't, because we stopped education at grade 6 by legislative fiat. And
I see what you're saying.
so,
You're saying that
so
we
is that,
changed the accreditation so
does
it's
that
so
meet
low.
whatever constitutional standard you would apply?
I think it probably does.
Really?
I don't like the answer, and I don't see it as a practical reality ever happening. But if I look at where do I find in the Constitution a source for a definition of what is a suitable education, if we're going to use that, I don't find it. Now, I know that Montoy said there is maybe a stage that will accept in Montoy what the legislature has done here and its definition applied. And maybe, if we get in the situation you suggest, there's a stage where it's unconstitutional. But I don't find traction for that in the language in this Constitution itself. So maybe I'm just flipping you back to the justiciability argument. I fear, but that's where I'm going.
Yeah. You were very complimentary in your briefs about the Common Core standards, and I'm wondering how to analyze that given the political realities that seem to be circling here. It seems like the Common Core is about as popular as Obamacare right now. But you advanced the Common Core as something that we should find comfort in. And so I'm trying to figure out how I analyze that argument.
Of course, I can only deal with what the record is on the Common Core as it was presented, and I don't think in the records or the brief some of the concerns that have been raised about Common Core find their way there. And I can only tell you that in what was presented at trial, there's every reason to be complimentary to it, that it does move it towards a more aggressive college-based curriculum, that it does provide advancements. My understanding to those who are critical of it now has been that it is we don't like the federal government telling us that we need to come up with something like this, or the other extreme, which would be that we don't think it goes far enough, that we have in this nation, in comparison to other nations, a problem in educating our kids, and that we need something more rigorous in Common Core. But on the basis of the record, it is more rigorous. It is an adjustment that makes it more likely that you'll have kids college ready if they're taught at that level under Common Core, and it's the sort of intellectual advancement or improvement that the Constitution speaks to.
I have a couple of other, I'm sorry to dominate this, but you'll have plenty of time. Did the state make any effort at trial to attribute poor student performance to problems with the local school district's particular programs or the delivery of educational services?
I'm sorry, did
you make any effort at trial to attribute poor student performance to inefficient or ineffective educational programs at the local level? In other words, it's your fault for not spending the money effectively.
No. The state did not attempt to introduce evidence that you have poor outcomes with a reducing number of kids, poor outcomes being defined by test scores because of money. The state did introduce evidence, and there is, of course, evidence, understanding the legislature has far more information about this on a continuing basis than what is introduced at trial, that would support that there are efficiencies that can be taken advantage of at the local level so that they have more money available to them. I want to make a quick comment about test scores and about student performance. I worry that takes this court down a path that is not productive, at least in the constitutional analysis, that if we look at test scores and if we say that becomes a key component to whether or not we have constitutionally financed, even if we assume that you can dump a bunch of money into the system and there's no control on how it's spent, that it will be spent in a way to improve performance, I don't think any of us would say that even one kid under that situation who's not performing under the test is insignificant. So where do we put that level of what's a significant number of kids passing test scores and what goes on there? And I think the answer to that is we have to focus on the opportunity as opposed to on test scores. Moreover, test scores by themselves.
Go ahead, I'm sorry.
Test scores by themselves are a snapshot on how a kid has done at a particular time on a test, whether they were sick that day, whether they just transferred in from another state, and don't necessarily measure the performance of the school. Secretary of State McNamara had it certainly wasn't an honor to have a logical fallacy named after him, the McNamara fallacy, which says you take a easily measurable, quantifiable variable, and you talk about it, and then if you can find variables that aren't easily measured, aren't easily quantifiable, then we don't include them in the analysis. And if you don't include them in the analysis, you conclude they're not important, and then you conclude if they're not important, they don't exist. And that's the problem here is that talking about test scores in and of themselves says nothing about whether or not you have an opportunity to an education. If we look, however, at Kansas and how it's done, and there's a graph that was part of the waiver that shows the movement of the kids on the bottom end to the people moving the kids on the top end on those test scores over time, what we see is a good picture. And we see in Kansas a top 10, according to the Association of School Districts in the country, program of providing education over the past years. So I'm not embarrassed about that. I'm just saying that we need to talk about the opportunity to provide an education, and we need to look at the deference that should be accorded to the legislature in making the decisions on what that funding level should be in the constitutional analysis, even if we find it's a justiciable question.
If we get into remedy and we order more money, do you think courts need to be in the business of also affecting how that money is spent?
If you get into the remedy portion, and if it is found that that it's appropriate to order spending of money, which I think Mr. McAllister would tell you would be a mistake, I think probably by necessity, if the court has taken that path, it would be involved, as it was in Montoy, in saying how it's spent. Which is one of the difficulties of taking that path that I think that the New Jersey courts and other courts have found, is that once you get into that tar pit, it's hard to get out.
Counsel, following up on Justice Biles' question a bit about the ability of the legislature, if they chose, to say we're only funding to a sixth grade level, and that's the end of public schools in Kansas, that's enough. And you questioned justiciability and gave an answer assuming justiciability of that question. So my question is, does that mean that you believe that every and any level of funding under Section 6 is permissible and non-justiciable, including zero all the way up to a whole lot? And if not, I thought I heard you say earlier, yes, there has to be a floor. So my question is, if it's not zero, where is it?
I appreciate that opportunity to clarify what I'm trying to say. And I don't want to be coming across as I'm coming from different places. If, and it is our position, it's not justiciable, then I guess conceptually zero is not, it still doesn't, even zero funding does not make it justiciable.
So is there no role?
Well, and the reason for that, I think, and Mr. McAllister has articulated, is you have no standard to measure it against. It ends up being a solely discretionary function with the legislature. That's the Baker Doctrine. And the question is whether it applies. Kansas has said we apply the Baker Doctrine, and the question is whether it applies here. If you have a justiciable issue, then our position, or at least the one I tried to articulate, is that you look at whether or not the legislative conduct is rationally related to its educational purpose, and that would include, I guess, the arbitrary notion. Now, I think probably what I should have responded to Justice Biles is, if you have a cut in half that is only in sixth grade, then I suppose one would find that lacks a rational basis, and that, or is arbitrary, particularly given where we are today to cut it to that degree. But I think the standard, assuming justiciability, with deference as it should go to the legislative determinations, should be measured on an arbitrary or or a rational basis test.
But if your premise and preference initially is non-justiciability, then what meaning does Article 6 or Section 6 have when it says legislature shall?
Well, I think that Article 6 is a provision that instructs that what the legislature will do in its discretion.
And to be clear, I'm talking about Section 6. I know it's confusing, but 6.6.
Thank you. Article 6, Section 6. The language shall is problematic to our position, but that's just only one of the factors you look at in the Baker analysis. I think the stronger point that argues as to why it's not justiciable, and Mr. McAllister's probably thinking he's going to jerk me off the podium at this point, but I think the stronger argument is that we have no objective standard against which to measure what the funding level should be. It's pretty easy to say 0 doesn't make any sense.
Well, it's pretty easy to say 6th grade doesn't make any sense.
And probably so.
And my problem with your answer about trying to say rational or arbitrariness is, yeah, I mean, you could use those words, but you could also just use the word adequate. The reason why a 6th grade education doesn't meet the requirement of Article 6 is it's inadequate. Now, I grant you that there's a lot of blurred lines once you get further, but that's a concept of adequacy. And it seems like if we have our foot in that door, it's okay to use the word adequate.
If we go to the door adequate and put our foot there, then the worry is when you get it away from stopping at 6th grade, where's the standard? And who makes that decision? Where that's always been the legislature's decision, and where the Constitution says it should be the legislature's decision. If we use the term suitable education as it evolved in Montoy, that became the difficulty, because we decided, okay, we'll use it in the context of what the state has said, but does the state's definition of it then, does that suggest that you can have moving constitutional obligations?
No, and again, that's where there's been some seduction by the courts going back over 20 years to say, you know, this is tough, trying to decide what these standards are. So I know what we'll do. We'll just use the legislature's standards, and then we're not intruding anywhere. And if we do that, then all we're doing is looking at what the legislature said it wants to do.
And if that's done in this case, then the harder questions that we deal with, which are, can we come up with a manageable standard, how do we do that, are resolved. Because what we have in this instance, we have a state standard, which is the accreditation standards that are being complied with and funded. So I guess we don't have to, in this case, try to tackle that more difficult issue of the absence of a standard. And I think that's why the courts have gone there. But I will tell you that at least it's the state's position, in my view, that is problematic, because you still don't have a definition of what is a suitable education, and it walks you into a path, particularly when you talk about adequacy, where the court, by almost its nature, starts putting its own value system and its own judgments on what is an adequate education, as opposed to leaving that to the legislature where the Constitution left it.
Why isn't it a fair standard, if we're looking at a rational relationship, to use cost? In the real world, to make suitable provision for finance means we're going to have to meet the costs of whatever that is.
Yeah, to some degree, if you're doing that, you can't ignore costs altogether. In this instance, you had a legislature that had, and I think to answer Justice Johnson and your question, Justice Luker, together, you had a legislature that probably felt that it did keep its promise, because it looked at what was actually getting into the pockets and being spent by the districts, and how that measured up against what the LPA study had said. In fact, I think in Montoy, the majority when it found that there had been adequate performance of its orders, or the orders had been met. My understanding of reading it is that they contemplated that you would look not only at the funding from the state, but you would be looking at least some of the LOB funding. It was the supplemental aid, the part that was coming from the state, that was called out, but of course that was discretionary, as Justice Rosen pointed out, as to whether or not you get supplemental, turning on whether or not there was actually a decision to have an LOB budget. So I think costs are something that would be involved in the rational analysis, but at least on the record in this case, particularly where those hard decisions on whether enough cost had been made as to whether a slight reduction in some costs would have an impact on the quality of education that's required, on whether dumping a huge tons of money, I mean, $1.5 billion that the plaintiffs want in this case would make any sense. Those decisions, I think, are left to the legislature. And I think it's that deference that answers how you look at cost. It's through that prism.
I'm not sure I understand are you arguing that if we would look at the 4 plaintiff school districts, that a combination of LOB, transfer of funds, federal funds, and state sources met the costs of the district? Or if you were saying it didn't meet the costs as they say it, but as the costs we see it?
I think that the evidence is that the cost, if you wish to use the LPA study as one point of reference, where it said, we don't care where it came from, we just want to know how much money we need to get to different schools in a particular context and under these ratings. If you take that measure and you inflate it, we don't talk about an update of the LPA study, which the panel didn't accept, but if you just look at the LPA study, and then we look at what money did the school districts actually get, ignoring the source, but they actually spent, but they were receiving more money than what the LPA study had said was necessary. Now, the cost factor, I suppose.
But that's your spending is at record levels argument, and I have trouble with that because it seems to me the one factual battle you lost pretty badly. I'm not sure it matters a whole lot in the analysis, but the one thing that you did lose, it seems to me, was this notion that school district budgets and school district services are going down, and salaries were being, and that's, I think it's Exhibit 254 is what my notes say. Salary freezes, educational operations, you had some pretty substantial testimony, even from Dale Dennis, that said, when you cut base state aid per pupil, you're going to cut educational services, and that's what's happened. How do you reconcile that battery of facts with your argument that records at spending levels, so it's all okay?
In the fiscal year 2010, there was a budget adopted, and then there was the allotments. So the school district's budgets were in place, they had made decisions, and then they had money pulled back from them effectively. That's where most of the data came from in terms of cuts. Many of the cuts, they did a good job of keeping the cuts away from education. But the reality of it is that at the time that decision was made, the funding levels exceeded what the LPA study had said was a necessary amount.
So how do you explain all of these service cuts and budget cuts and salary freezes
and it's because
dismissals of teachers and the litany of things that were testified to?
Well, it's because they're getting less money at least in that year, than they had budgeted, and they are getting less money than they desired in subsequent years. You still have I see it as two different things. You have the LPA study that was an attempt to try to, by way of costs, define what you needed by a certain amount. Then you had what it was the districts were getting. They were getting more money, and as I think happens in government frequently, you spend the money you get. And when now we look at what are relatively small amounts of cuts, I think it was about 1.5 one year, 0.5 down the next year. It's been up the last couple of years by about 3% in terms of spending monies that are available. You're going to find that there are programs that are cut and reduced. They kept them out of the classroom. They were for a variety of different things, and I'm not trying to minimize any. All of them can be important, but in trying to make a decision on what is appropriate level of funding, it certainly would not have been irrational for the legislature to say this, particularly in hard economic times, is what we can afford and what's appropriate to provide. Particularly when you measure it against, if you need to measure it against anything, the level of funding necessary to keep the schools fully accredited to provide those programs that have been defined by statute and then by the regulations as being at least those required programs and classes and teacher level and teacher quality that we need to have in order to keep our schools accredited.
Part of the, shifting just a little bit, but part of the same line of questioning, is most of these, the historic kind of perspective of school finance cases is partly addressing wealth-based disparities. And what the legislature and the executive branch proposed last time and promised that they would do, not only to help address those concerns, were the local option budgets that would address equalization, and the other was the capital outlay equalization that no one's really talked about this morning, but that has been completely ignored since 2008, and I don't think a dime has gone into capital outlay equalization. And the panel found that that trend exacerbates the wealth-based disparities that the last case was designed to cure, or at least to address. And how does not, or ignoring the capital outlay equalization, not getting a dime, force districts to use money that was meant for equalization and meant for that, and not utilize that source of income for capital outlay, and then affect the wealth-based disparities that we're all very conscious of?
Okay. Thank you for the opportunity to respond to that question.
You're welcome.
On the wealth-based disparities, there is certainly in property valuations a wide spectrum from Galena to Burlington. When the rubber meets the road, however, and looking at what the levies are in those different districts, it's about a 20 mil difference, which is about $250 or $260 to a $100,000 house. Now, I use that as a backdrop to answer your question. Capital outlay, as I understand it in Montoy, became a larger issue because historically, before Montoy, you had built up, not only in capital expenditures, but also in those things that went to the maintenance and so forth, a large difference between certain more wealthy districts and those that weren't. And so the effort was trying to historically bring that back into balance. When that is balanced, I suppose, would be one issue. Then you have what the record was with the legislature, and that is they looked at what capital outlays were and what the budgets were. Were districts taking advantage of their ability to levy the full amount of 8 mills for capital outlay? And on average, it worked out to be about 4 that they were doing. And they also looked at the balances in the capital outlay funds. Were they being spent? And that is, in short, was there a need? Was the historical problem one that appeared to be solved? And then what the legislature, I think, rationally did is said, look, we've got only a certain amount of money that we feel that we can raise and pull out of this budget, 62% of it going to education. And we want to put it where it's used the most or the best. So what we'll do is we will put it in to make sure in the general fund that you have a higher base and more funds available there. And that has the effect of, for those districts who historically have had the larger problem with capital outlay, those districts that are poor, those districts are also the ones that tend to get more in ratings. So you can put it into the base, you can send it through with the ratings, and you can effectively put more money where they think it can be needed. And then with the changes in some legislation, it used to be money was pretty well directed into different silos and you couldn't move it. They made it so it could be moved around more readily so that if a district found it had that need for capital outlay money, it could use it from its operating budget. Now, does that lead to
But that is still, by eliminating the capital outlay equalization payment, you're still dealing with less dollars in the silos. You're dealing with zero over here, and then you're getting what you get from LOB and base state aid.
The question is whether it was a reasonable thing to do under the setting, given that the question is whether the legislature could have reasonably concluded that, based on the information available to it, funds being held in the capital outlay, looking at capital outlay spending, whether that was a rational thing to do, to move it to that other section to try to deal with the wealth-based disparity. Now, the wealth-based disparity, I don't want to minimize it, but it is a rubber meets the road sort of thing, and that is, do we find schools that are unable to maintain their capital expenditures with capital outlay? And there wasn't that evidence. Do we find schools that are unable to come up with the capital money? And we didn't find that sort of, in order to build those things, we didn't, to build buildings and so forth, we didn't find that sort of evidence.
And how do we criticize a poor school district for not taxing its people more? I mean, that's the whole notion of wealth-based disparity. And I understand what you're saying about deference to the legislature, and so that deference might come into play with the LOB equalization. I mean, should it be 80? Should it be 85? Whatever. You can look at that and draw lines in different places. But with capital outlay, it's zero. And so it doesn't seem like a whole lot of deference has to go into that analysis. It is a boatload of money, because 8 mills, if it was leveraged across all of the property wealth, is a lot of money, and none of it is equalized. And that seems to be a fairly dramatic wealth-based funding formula that just might jeopardize the equity notion that Mr. McAllister talked about under Article 6.
Well, I agree with just Mike. If you have a wealth-based, a tax base, because now we're talking about taxes now, we're not really talking about schools anymore. And we're saying it's unfair to this taxpayer or that. And of course, people have decisions that they make on where they wish to locate. A good friend of mine wants to live in a small community where his tax base is lesser, no doubt, but because he doesn't want to be around people like me, I guess, in Wichita. Or people want to live in Wichita because it offers certain advantages. There's always going to be tax-based disparities. There's always going to be wealth differences in terms of what you can generate. The question has to be, how does that impact what we're reviewing? And that's the rubber meets the road. That's where was the evidence to the panel to say that by reducing or not paying, in this instance, money in equalization to capital outlay, that schools are not able to do what they need to do, particularly when that money is brought in another direction through the general fund and when it's available through the general fund under the weightings that are more favorable in many instances to those schools that have the wealth-based disparities.
Is it an ability not to do it, or is it that they have to work a whole lot harder so it's not fair? It almost seems like ability touches back to adequacy. In other words, is the building falling down versus how much harder we make it for a property poor district to be able to buy a projector.
And that's why I think that, again, when I mentioned that the records now show that the distribution between mill levies, those that are working for it, if you will, is the 90%, in that middle range, is a 16 mill swing. It's between 40 and 60 mills is mostly the difference, which works out to be, according to my notes, about $230 a year in a $100,000 house. Those districts, incidentally, that are on the upper end, the Burlingtons, they tend to be rural districts. In fact, I think the few districts now that don't receive any sort of equalization aid for LOB, which would be a parallel, are the rural districts that have some sort of resource, power plant. But that doesn't mean necessarily you've got rich people. And when you're looking at the mill levies, the point is that we don't see a wide range of effort. We don't see someone having to come in and have many multiples of mills in order to get the schools they need, or the alternative, the inability to do that and then not have the schools.
Do you have a record citation for what you were just reading to me about the mills?
The Tillman is not going to be, I'll have to get it to you. It's from the Tillman, it's the transcript. It's Mr. Tillman's testimony at page 1121, and Your Honor, that doesn't, we'd have to look back at table of contents to correlate that. Unless you have any other
further questions for counsel.
I do. I'm going to take you back to your answer earlier where you said that there's no challenge to a zero appropriation of monies. Does that mean then that Section 1 that essentially says that the legislature shall establish and maintain public schools, that's precatory also, and that if the legislature fails to maintain public schools, that there's no one can do anything about it?
Well, it is the logical outgrowth of the justiciability argument, and it is the application of the Baker test that gives that response. As to no one doing anything about it, absolutely not. What that does is it trusts the electorate to make sure that the schools are funded.
And so if the legislature says that we now define a jury as being the presiding judge, then we can't say there's a violation of the right to a jury trial if you have court trials because the legislature's said that the court's the jury?
No, Your Honor, I don't think that the Baker standard would begin to say that the jury trial is something that's not justiciable or the denial of the jury trial.
Any further questions of counsel? Thank you, counsel.
Thank you, Your Honor.
Alan Roop for the plaintiffs in this case, school districts and kids in Kansas. Professor McAllister and Mr. Chalmers have done, as expected, a nice job of explaining their positions, but I think we need to do a little bit of a reboot here and go back to the fact that there was a trial and that a panel that was legislative specifically created by the Kansas legislature to hear school finance cases and appointed according to the statute, listened to the evidence and made certain findings. We've heard a lot about what they didn't find, but I want to focus, because I think it impacts some of the issues you may be concerned with, including standing and some other issues. I want to focus on what the trial court found as a matter of fact. And in that regard, as you've indicated in previous decisions, those findings of fact are entitled to substantial deference. I then want to talk a little bit about the jurisprudence of school finance that goes back some 40 years and goes to the Caldwell case and forward through a number of school finance cases we're all familiar with. Because I think we have to put the state's arguments in the context of what those cases say. And make no mistake, so as we proceed, we're on track. The constitutional language that we're going to be talking about and your court decisions interpreting that language are entitled to the same weight. So let me do my reboot here for a second, and I think there was a leading state official who through a document, Exhibit 121, testified at trial, gives you a pretty good idea of what the state of education is in Kansas at the time the Gannon case was tried. If children don't learn to read early, they are likely to face a lifetime of difficulty in the classroom and the job market. 28% of our students are reading below basic levels. That number is far too high. Only 25% of our students are reading proficiently. That number is far too low. We also need to increase the percentage of high school graduates who are college or career ready. High school graduates today not only need their degree, but also need skills to succeed in the global marketplace. Those were the words of Governor Sam Brownback on what the state of education is today. And that's found in Exhibit 121.
And isn't that his policy statement, the statement that he's elected to espouse for the citizens of the state of Kansas, just like the legislature? And what business is it of ours to talk about literacy rates, achievement, and all of that when it comes to these questions? I mean, I think that's the heart of this justiciability question. Isn't that's what he's there for?
Well, my answer is simply this. It's the Kansas Constitution that provides a suitable education. And it was in...
It doesn't provide a suitable education. That's not the wording of the statute, of the Constitution.
You're correct, Your Honor. Suitable provision for finance. And in Montoy 2, this court said, first and perhaps foremost,